Melissa from Judge Ludwig. Jim is just getting an attendance for today's 10:30 hearing in 19 CV 484. Do I have anybody on the line for the plaintiff?
George Burnett. Mike Greenspan.
April Barker here as well for the plaintiff.
And anybody for the defendant?
This is Lita Walker from Ballard Spar on behalf of Netflix.
And this is Kevin Vick on behalf of defendants Laura Ricciardi, Moira Demos, and Chrome Media.
This is James Friedman, Godfrey and Kahn on behalf of all defendants.
This is Laser. Pardon me.
I'm sorry, this is Matthew Kelly from Ballard Spa on behalf of Netflix. And this is Jeff Payne on behalf of defendants Chrome Media, Laura Ricciardi, and Moira Demos.
And any other appearances on the line?
This is plaintiff Andrew Colborn.
Thank you. We'll begin shortly.
This conference is being recorded. Only the main conference is recorded.
Now calling case 19 CV 484 Colborn versus Netflix Inc. et al. No appearances in the courtroom. Can I get appearances by phone, please, starting with counsel for the plaintiff?
George Burnett on behalf of Mr. Colborn, who appears personally as well.
April Barker of Shotwell listener April also appearing for the plaintiff.
And attorney Mike Greenspan also appearing for the plaintiff.
And appearances for defendant Netflix Inc.
Lita Walker with Ballard Spar.
Matthew Kelly with Ballard Spa.
James Friedman with Godfrey and Kahn.
And appearances for defendants Chrome Media, Laura Ricciardi, and Moira Demos.
Kevin Vick from Jassy Vick Carolyn.
And Jeffrey Payne, also of Jassy Vick Carolyn.
And James Friedman from Godfrey and Kahn.
Any further appearances? No further appearances.
recite the procedural background. On December 17th of 2018, exactly 2 years ago today, the plaintiff filed a defamation complaint against Netflix, Chrome Media, and others in Manitowoc County Circuit Court. The defamation complaint related to the Netflix series Making a Murderer. On March 4th of 2019, plaintiff filed an amended complaint that named only Netflix, Chrome Media, and two individuals, Laura Riccardi and Moira Demos. On April 3rd, the defendants filed a notice of removal, invoking this court's diversity jurisdiction. On May 9th, Netflix moved to dismiss under 12b-6, contending that there was no plausible claim for defamation alleged in the complaint. On May 10th, Chrome Media filed a motion to dismiss, indicating there was insufficient service of process under 12b-5. In sum, that motion to dismiss alleges that contended that the complaint was filed on the last day before the statute of limitations expired, based on the timing of the airing of the Making a Murderer series, and that the plaintiff had failed to serve within the 90-day window provided by this stat section 801.15.1b. The court, Judge Pepper, who was then assigned to the case, conducted a hearing on December 19th of 2019, a year ago, and at that time she denied Netflix's motion to dismiss, plausibility-based motion to dismiss, and then concluded that the issue on Chrome Media's motion to dismiss was subject to disputed facts. She granted plaintiff leave to file a second amended complaint. Subsequent to the hearing on January 3rd of 2020, plaintiff did file a second amended complaint against Netflix, Chrome Media, and Riccardi and Demos. The parties later entered into a stipulation that the producer defendants, Chrome, Riccardi, and Demos, would not be required to respond to the second amended complaint until the pending motion to dismiss was resolved, and they also agreed Netflix would have 60 days to respond to the second amended complaint. On January 16th, the court entered an order setting an evidentiary hearing for March 6th on the service issues. That hearing was later reset a couple times due to COVID. On March 3rd, Netflix filed a motion to dismiss the second amended complaint. In that second motion to dismiss, Netflix contends that the defamation claim, even if plausibly alleged, fails as a matter of law. That motion was fully briefed as of June 1st of this year. On September 21st of this year, the case was reassigned from Judge Pepper to me. I held a status conference on October 22nd. The day before that status conference, plaintiff moved to compel discovery. Essentially, the defendants have declined to provide responses to the initial mandatory disclosures required by Rule 26, and apparently have also failed to respond to other written discovery. At the status conference, we talked about the pending motions. The court questioned whether an evidentiary hearing was really necessary on service issues, given that from the court's perspective, it seemed like the facts themselves of Tempstat service were not disputed. It was really a characterization of those facts and the determination of what those facts meant under the law, significance of those facts. We also talked about Netflix's motion to dismiss, the second motion to dismiss, which the court observed seemed to rely on a lot of extra non-pleading materials, making it look a lot more like a summary judgment motion than a motion to dismiss. With respect to the issue on the motion to compel, the court indicated I would wait for the briefing to be completed before I would resolve that. I then set this continued status hearing for today, and with respect to the service issues, I ordered the parties to file statements of fact and to try to agree on as many facts as we could with respect to those service issues. Since that time, the parties have completed briefing on the motion to compel. And then on November 23rd, the parties filed statements of fact, joint and partisan, I'd say. There are some agreed upon facts and then some disagreements on what those facts mean. Also on November 23rd, the plaintiff filed a summons returned unexecuted against Crow Media. And I'm not exactly sure what the significance of that was, but it does raise some questions with me. So anyway, that's the background as we come to today's hearing as far as the court's aware. Before I get into the various pending matters, I guess I'd ask lead counsel for each of the parties to confirm that that's a correct recitation, and also to let me know if there's anything new or additional that should be brought to the court's attention before we turn to the pending issues. Mr. Burnett?
Yes, Your Honor, I defer to Ms. Barker on the court's questions, but it sounds like a correct recitation to me.
Thank you, Your Honor. Yes, thank you, Your Honor. The court's recitation of the procedural background is correct. With respect to a brief response to the query regarding the summons returned unexecuted that was filed at the same time as the joint stipulated facts and the separate facts submitted by the parties. One of the arguments in brief that the defendants had raised in favor of their service motion was that the plaintiff could have easily obtained service on Chrome Media by means of using the New York Secretary of State. With respect to the second amended complaint, that route was therefore attempted and proven or established that that can't be accomplished because that means of service is only available for actions venued in New York State or federal courts. So that's the significance of that. It's really another fact. I got it.
And that was sort of my surmise.
Thank you.
A follow-up question, though, is Chrome Media has appeared here as Chrome, and this docket is very long, and there's a long history before I got involved. Has Chrome Media been served with any of the prior complaints? And I'm not. Obviously, there's the issue of timeliness is a different issue, but is there a question as to whether Chrome Media has been served with process in this case, regardless of time?
Yes, Your Honor. There was service of Chrome Media, I believe I want to say June of last year, and at the time it was plaintiff's position that and remains plaintiff's position that the service would have complied with additional time for service under the federal rules following removal. Judge Pepper, in all candor, I believe, disagreed with that analysis, but that is in the record that there was service in June of 2019 of the original complaint and amended complaint, and then there was service as well of the second amended complaint. And I believe that those, I'll have to double check when those were accomplished, but that was accomplished as well.
All right, thank you. Ms. Walker, any additions, corrections to the procedural recitation? Anything else that the court should be aware of?
No, Your Honor, you have it all right.
Thank you. Mr. Vick?
The same thing. You have it all right. No corrections.
All right. And Mr. Vick, one question for you. It's the sort of same follow-up question I asked Ms. Barker. Leaving aside timing, does Chrome Media at this point dispute that it's been properly served with something, or it's been served with something, maybe untimely, but it's been served and is in the case? Is that disputed?
It is disputed whether we're properly in the case, Your Honor, because if service was not effected in a timely manner, then under the law that we cited in our motion to dismiss, we should be out of the case. So, the later service is just a nullity. It's ineffective.
Yeah, I think that's wrong, but we'll get to that. So my main question is whether there was subsequent, again, regardless of timing, whether if we leave the timing aside, whether the producer defendants have at this point been formally served.
I believe the answer is yes. Yes, Your Honor. Please don't hold me to that because I haven't focused on that issue. I believe there was, service well after the deadline that Judge Pepper said was the do or die date. So that's what I could tell you now. I believe the answer is yes, but I don't know for certain that there aren't issues with that service.
All right. So thank you. So let me turn first to what I'll call the producer defendant's motion to dismiss. And I've reviewed the motion, the brief, Judge Pepper's January 16th order, which discusses some of these service timing issues, and also the parties' various statements of fact. And I don't think we need an evidentiary hearing. I don't think the material facts are in dispute. The real issue is, was there reasonable diligence based on the facts that are recited, and I don't think that's something that testimony aids. That's just something that a characterization or a conclusion that's a determination that should be drawn from the facts that are not from the actual activities of the parties, which are not disputed. And so was service by publication actually achieved? I think both of those can be resolved based on the stipulated facts. But I have two sort of follow-up points, issues that I'd like to raise with the parties. The first one relates to the discussions I just had with Ms. Barker and Mr. Vick. So the producer defendants have moved for dismissal under 12b-5 for insufficient service. And I think, well, I understand that point. I don't think it's necessarily procedurally correct. Because I think the court can extend the deadline for service under the federal rules. And so I could extend service. Now, what I think I can't do is extend the statute of limitations. So the issue here is not really one of insufficient service, because I think at this point that's sort of been accomplished, but rather whether the statute of limitations expired before service was accomplished. Because 893, WSStat section 893.57 provides that an action for defamation must be commenced within 3 years of accrual. And 80102 provides that an action is commenced upon the filing of a summons and complaint with the court, quote, provided service is made within 90 days after filing. It doesn't say provided that service is made timely. It says provided that service is made within 90 days. And even in federal court, I can't change that statute. Even if I could, I think I can extend the deadline for service, but even if I do that, it doesn't save the statute of limitations. So I hope that makes sense to folks. And so what I'm going to do is treat this motion really as a motion to dismiss based on the statute of limitations under 12b-6. I don't think that really changes, and again, it's more of a procedural point than anything else. I don't think it really changes what anybody's arguing. It's just a slightly different way of thinking about it. And I come to this slightly different way of thinking about it because there are allegations in the second amended complaint concerning making a murderer part 2. And so, which causes me to wonder, even if the court were to agree that service was not properly made within 90 days of the initial complaint, and frankly, I'm leaning that way, if that's the case, claims based on the original theories against the producer defendants would be barred by the statute of limitations. but I think plaintiff would still be able to maintain claims based on the second series, because those claims would have been made within the statute of limitations. And I guess I would like to hear from Mr. Vick on that issue.
Yes, thank you, Your Honor. First, I would say on the first issue, I must confess this wasn't one that I was prepared to address. Whether or not the court could extend the time to serve, I believe, I'm looking back into the briefs that we filed. I believe there were a couple of cases that we cited, and maybe cited in Judge Pepper's order too, the Allen v. Ferguson case and the Cobb v. Arameric, which I'm seeing on page 7 of Judge Pepper's order. And I'm looking at Allen v. Ferguson and seeing, in determining the validity of service prior to removal, a federal court must apply the law of the state under which service was made, and the question of amenability to student diversity actions continue to be governed by state law even after removal. So, to the extent that Your Honor is entertaining the possibility of the post-March 18th service being effective to somehow potentially keep the producer defendants in the case, we would respectfully request an opportunity to brief that, and looking at those. And it may be that we already have that in our papers, but I don't know that the issue was addressed square on, because it didn't seem to be one that Judge Pepper was interested before. Now, as to your second question about the nature of the allegations in the Second Amendment complaint, there are allegations in the Second Amendment complaint as to Season 2. However, if you then go and look at the allegations for the individual claims, you notice that the individual claims are not premised on those allegations regarding Season 2. And that's a matter of just going back, looking at the complaint, looking at the paragraphs. So, we view those allegations in Season 2 as, it may be sort of background flavoring, but it's not the gravamen of the actual claims themselves. So that would not be a way to get the producer defendants back in the case in any way. So those would be my responses to those. Another couple cases that I think we cited that addressed the issue of, the latter amended complaint being a way to try and draw people in if you've already blown your deadline to serve them. Other cases were...
Stop. The difference here is that the statute of limitations, I'm inclined to agree with you that the statute of limitations was blown after the first series, and so defamation claims based on that series are barred by the statute of limitations. And I agree, I can't change the service rules, give them more time to serve it, and get around the statute of limitations under state law. I agree with that. But the issue here is, now they've got essentially a different set of allegations, a different claim, or a different basis for their defamation claim that would be within the statute of limitations. It's not barred by the statute of limitations. So, so they could serve, they could amend their pleading based on these more recent events, which they have, and assert claims against these defendants, and serve that amended complaint. That would be entirely consistent with federal procedure. It would be entirely consistent with state procedure, and it wouldn't violate the state statute of limitations. All these other cases, the cases that were cited, deal with situations where people are trying to evade the statute of limitations, and I agree, you can't do that. But it seems to me these new claims, based on the second series, which for which the statute of limitations has not run, there's no reason why the failure to serve the original complaint, which did not contain those, would bar the plaintiff from proceeding against the producer defendants on these other claims. Now, let me say, sort of in response to one of the arguments you made, whether the allegations related to the second series are, state of claim, whether they're defamatory, etc., whether they're sufficient, that's a different issue. That's a 12b6 issue. That's a summary judgment issue. That's a merits issue. It's not a service issue. And even if I were going to go that route, certainly the producer defendants would have the ability to make those arguments. But that's sort of my thinking right now. And obviously, if this is a different way of analyzing it than Judge Pepper did, but I think, to be fair to Judge Pepper, she didn't have that second amended complaint and the allegations related to the second series when she was analyzing this. And I do think that adding those subsequent statements and subsequent facts may be enough to, it changes the analysis. I'll give you a chance to respond to that.
Thank you, Your Honor. I would say first, as to Judge Pepper, the motion for leave to file a second amended complaint was filed back in 2019, and I believe that the second amended complaint itself was filed on January 3rd of 2020, and then she actually issued her order regarding the 12b5 motion after that on January 16th.
Yeah, but
so
she wasn't analyzing that second amended complaint. And
that may be true.
And frankly, even if she was, I'm not bound by it, but go ahead.
Fair enough, Your Honor. I guess I may have not been clear in what I was stating. What I was stating was that although the plaintiff keeps talking about the second amended complaint, what I would ask Your Honor to do is to look at the claims in the second amended complaint themselves, the causes of action, and I think it will reveal that those claims they don't cite back to, they're not based on. If you look what they actually complain about in the claims, they're not the allegations regarding season 2. So I think that's a little different, and it's also a little bit worrisome here because this sort of gives a roadmap for a party to get around the problem. If they haven't served us timely, and then they amend the complaint and they just throw something in, and then they get to bring us back in as a party. For sort of policy reasons, there's a lot of trouble with adding, not limited to the fact that, as the parties have already indicated, there could be issues here with regard to discovery, including the application of journalist privilege, which I know that plaintiff opposes. We obviously think it would apply, and the plaintiff has made a big point about how they think it matters, whether or not the producer defendants are parties to the action. So, this is a concern. There's sort of heightened concerns here for machinations that may be trying to place the producer defendants back in the case, notwithstanding the expiration of the statute of limitations. So with that in mind, I would just ask Your Honor to take a look at those allegations closely, because that was something that jumped out at me when I saw the parts in the opposition to Netflix's motion, basically where the plaintiff talks about the second amended complaint, and then I went and took a look, and I just don't see that the claims are based on it.
Right. I'll do that. And as I said, even if I were to ultimately rule that the statute of limitations bars the claims based on the first series, but not the second, and so the producer defendants remain in the case with respect to claims based on statements made in the second series, and I will go back and look at the second amended complaint as you suggest. But even if I go the route that I'm thinking I will, certainly the producer defendants would have an opportunity to respond to the second amended complaint, and it wouldn't shock me if that response was a motion to dismiss for some of the reasons that you're arguing right now. So even if I go even if my analysis continues, even if I adopt the analysis I'm thinking right now, it would not mean that you would be precluded from making the argument you're making right now. I'm just not sure that that's where we are right now. Anyway, Ms. Barker, anything you wanted to say on any of that?
Yes, Your Honor. Thank you. I'll be very brief. I just want to clarify with respect to procedure, just to be precise about it. I guess the individual defendants have, and I'm including Chrome in that category, have argued that everything is essentially frozen under state law analysis as of because the matter was initiated in state court. I think as we've briefed and the court is aware, it's the analysis of the service of process efforts that were made prior to removal that is governed by state law, not all procedure in the case, as I think the court has correctly identified. After removal, the case then proceeds under the federal rules. I want to just also preserve for the record our argument. I understand that this is something Judge Pepper had rejected, that that this is Hannah versus Plumer, not a Walker case, so that the statute of limitations, in our view, under Hannah versus Plumer, the federal rules regarding removal would in fact take precedence over the state statute of limitations, but that may be an argument for another day. With respect to the issue of the Second Amended complaint, I can certainly say that there was an intent to base claims on the Making a Murderer 2 as part of the Second Amended complaint. I will go back and look at it as well. I just had some trouble pulling it up just now. Of course, my computer froze while I was trying to do that, but it certainly was the intent that those allegations were not somehow just window dressing or, superfluous. Those were intended to allege facts in support of the defamation claims in the Second Amended complaint. And I also would just note that this isn't just some kind of machinations or gamesmanship, as the defendants have suggested. Making a Murderer 2 has given rise to claims that the plaintiff fully intends to pursue as well, and those claims are not barred by a statute of limitations under any argument that we can conceive, even assuming for the sake of argument that the Making a Murderer first claims would be barred, and again, we preserve our arguments for review on that. But with respect to the Making a Murderer second claims, if the court were to hold that those were somehow not implicated or raised in the Second Amendment complaint, first of all, I'm sure we would seek leave to amend to clarify, but if not, if those were somehow dismissed, they could not be dismissed with prejudice, as the plaintiff or the individual defendants have requested with respect to the original complaint. They would have to be dismissed without prejudice, as there is no plausible statute of limitations argument with respect to those claims. And, playing this through, if the plaintiff would have the right to reassert those claims in state court, presumably there would be another notice of removal, perhaps a motion for consolidation. It would be a lot of essentially procedural machinations that would be required under that scenario. So it is not plaintiff's intent to engage in any gamesmanship or machinations by bringing those in. He's simply trying to validly assert these claims in the most efficient manner possible.
Yeah, thank you. And that's one of the reasons I was asking about whether the service had been accomplished at some level, even if it was untimely. Because I do think that focusing on service is kind of misses the point here. The issue is statute of limitations. The court can allow service, late service, fine. The Wisconsin statute of limitations is not tied to service. It's tied to not tied to timely service. It's tied to service within 90 days after filing of the complaint. That's 90 days, and I cannot change that. It would be different, I think, if 102 said is commenced upon filing of the summons and complaint and timely service, then I think we'd be in a different setting. But so those are my thoughts on that first motion. With respect to Netflix's motion to dismiss, I've reviewed that in some detail. I have a couple of concerns still that Judge Pepper, they've already had one motion to dismiss, and Judge Pepper denied that, and this seems like kind of a second bite at the apple. I realize it's maybe a bite at a different part of the apple, based on different theories, but that still is a little troubling to me. I'm also troubled by the fact that this doesn't look more like a summary judgment motion under Rule 56 rather than a motion to dismiss under 12b6. But I appreciate that, a lot of the arguments that are made are based on items that are of public record and also items that are incorporated and attached to the complaint. So I've spent some time going through that stuff. I will say I'm not prepared to rule on that motion today, but I will make the following points that I tend to agree with the defendants that they have the First Amendment right to argue and present evidence on a theory that Mr. Avery was, set up. I think the First Amendment gives them the right to do that, even if it's disputed and even if somebody would disagree with it, even if it's not, in fact, what actually happened. I don't know. What I don't think the First Amendment gives them the right to do, though, is to knowingly present misrepresentations in support of that theory. And I will say that certainly the allegations that there were excerpts of trial testimony that were doctored that present a question followed not by the answer to that question, but by the answer to a different question, I think that is troubling. I think those are misrepresentations of fact because the broadcast represents that this is how this person answered this specific question. And in fact, that's not how that person answered that question. Now, I think that's a false representation, and it's done intentionally. I think that's different than somebody simply presenting a summary of someone else's testimony in the author's own words. That's not this. This is like a recording of something that was allegedly changed to misrepresent what the answer to the specific question was. Now, whether those doctored excerpts are material or not, and whether they satisfy the other elements of a defamation claim, I'm not sure. But I think those specific instances are troubling. So that's my current thinking on that motion, and I'm sort of presently inclined to deny it, but I'm still working through all of the elements and the case law. The final thing to address today is the motion to compel the initial disclosures. And I will say that under Rule 26A1C, a party is required to make those disclosures at or within 14 days of the 26F conference unless parties agree to a different time or the court sets an order for a different time. Or the rule allows a party to object during the conference that initial disclosures are not appropriate and put that objection in the plan. The defendants have done that, so they've complied with the rule. And I note that there's this under Rule 26D1, the plaintiff can't seek discovery from any source until the parties have conferred as required by 26F, unless the proceedings are exempt from initial disclosures, or there's a stipulation, rule, or court order otherwise. The plaintiff has reported having served additional targeted discovery requests that have not been answered. Defendants, I don't think, have a basis not to answer discovery or to give themselves a unilateral self-imposed stay of discovery. They should have come to the court and asked for a protective order on that. If those requests had included a request for admission and those were not answered, I think the plaintiff would have a very good argument that those would be deemed admitted at this point. I don't know if that's happened or not. Regardless, given the circumstances of the procedural sort of morass that we find ourselves in, I'm not going to make the defendants answer discovery right away. I will, however, order that the defendants must provide initial disclosures and responses to any overdue pending discovery requests within 14 days of the court's final ruling on the pending motions to dismiss if the cases proceed, if the case proceeds. if the motions to dismiss are granted, obviously that moves the whole thing. But if the case survives, the defendants are going to be required to turn around responses promptly. So, where do we go from here? As I said, I've sort of reviewed all these filings. I've taken my time to go through this, what is a very long and extensive docket for a case that's now been pending for 2 years. And I'm trying to figure out a way for us to move forward efficiently. At the last hearing, I think it was Ms. Walker suggested that, when I asked how we could efficiently move this case forward, she said the most efficient way would be to grant Netflix's motion to dismiss, because that would get rid of the case, and the producer defendants would be entitled to make the same argument, so we could resolve the case for them too. And I think Mr. Vick eagerly agreed with that approach, and selfishly, I think that is tempting, but it's not how the court operates, and we try to take our responsibility seriously. So, as I indicated, I'm presently inclined to conclude that plaintiff's claims based on the first series are barred by the statute of limitations, but I'm also inclined to conclude that Netflix's latest motion to dismiss does not resolve the case. That being said, this case is complicated, and I'm going to spend some more time going through that and work on a decision. But this case has been pending for a long time, and I'm assuming that the parties would very much like this to be over sooner than later. And if you don't, you probably should. So one of the things that occurred to me as I was going through this is I almost never do this, but I'm going to order the parties to mediate the case now before I issue my decisions on these pending motions. And I'm going to order you to mediate in front of one of our magistrate judges who will mediate the case without cost to the parties. I'm doing that because the case has been pending for so long, and I'm hoping that sort of the time and delay has made the case sort of more ripe for a resolution, because again, I do think the parties should be interested in a resolution consensually. With respect to the plaintiff, I think, I've reviewed the allegations in the complaints, and I can certainly understand why the plaintiff is upset. As I indicated before, I think the splicing of the trial testimony in particular it kind of offends me, and I can understand why the plaintiff would be offended by that and upset by that. I also understand that, the social media being what it is, that he's had to deal with some unfortunate kind of understates it, some really problematic attacks. But at the same time, I'm not sure what his actual damages will be, what recovery he'd be able to prove, and frankly, I'm hoping that enough time has passed that maybe he's in a position to sort of resolve this and move forward with his life. I'd certainly encourage him to do that. By settling, he avoids the risks of litigation, the cost of litigation, a real potential loss on the law, because defamation cases are not easy to prove. They're hard to win at trial, and they're even harder to preserve on appeal. So I think there should be a strong interest on plaintiff's part to settle this case now. Again, now that time has passed. With respect to the defendants, I would also encourage the defendants, I would think the defendants would have an interest in resolving this. I think even if the producer defendants are out based on the statute of limitations, they may still be subject to claims based on the second series. Frankly, they may also still be somewhat involved in the case, because it seems to me Netflix may have a claim against them for indemnification or contribution. I don't know what their contracts say, and perhaps there's an equitable claim even if it's not addressed in their contracts. At the same time, they've gained a fair amount of fame and standing and compensation as a result of these documentaries, so they've benefited. discovery and trial of this case will not be inexpensive. I would think an adverse verdict would not be the kind of publicity that a filmmaker would want. It would seem to me that it would make sense for them to want to exit this case now, without further expense, without any finding of liability or wrongdoing on their part, and without any further negative publicity that would come from an adverse result. I think largely the same points would apply to Netflix. It's obviously a very successful company at this point, and frankly, these documentaries have been a part of its success. Discovery and trial won't be cheap. There will be not just the cost of outside counsel, but you have the internal distraction of personnel having to provide discovery and deal with this case. And I think they probably don't want negative publicity either at this point. So I think a reasonable settlement ought to be able to be reached, and that would be in the interest of all parties. So for all of those reasons, I'm going to take the motions to dismiss under advisement, and I'm going to order the parties to mediate. If you don't settle, it is very likely this litigation is going to continue, at least in some fashion, with associated costs and risks for all parties. So I want to strongly encourage folks to talk to each other and try to settle consensually. My inclination, as I said, is to refer this to the magistrate judges for mediation. If the parties would prefer to pick a private mediator, that would be fine with me. But so I give you that opportunity. And so what I'm going to do is I'll give the parties essentially 2 weeks till January 4th to report on whether they've agreed upon a private mediator. If they haven't, January 4th, to January 4th to agree upon a private mediator. If you don't agree upon a private mediator by January 4th, the court will enter an order referring the case to one of our magistrate judges for mediation. If I could skip that, if the parties just want me to refer it directly to the magistrate judge right now, I'm happy to do that. So that's my lecture for the morning. My current thinking on the case. And let me start, I guess, with Ms. Barker. Any thoughts on a mediator? Is the plaintiff content to have me send this to the magistrate judges, or would you like the opportunity to see if you could agree on a private mediator?
Thank you, Your Honor. On this question, I apologize for going back and forth, but I think Attorney Burnett would actually be best equipped to answer that question. I do have one slight procedural clarification I wanted to make, and I could make that later if the court wants to address the mediation issue first.
Let's deal with the mediation first. Mr. Burnett?
My preference, Your Honor, would be take the opportunity to talk to the defendants, see if they have some thoughts on a private mediator, and report back to the court by the 4th.
Okay, if that's the plaintiff's position, that's fine, and I won't even bother the defendants with the question, because if the plaintiff wants to do that, I'll give them the time to do that. So that's what we'll require. Ms. Barker, what was your follow-up point?
Thank you, Your Honor. I think that the court is aware of this, but just because of the complexity of the procedural status and the different motions, I wanted to make clear for the record that the statute of limitations argument has been asserted by the individual defendants, but not by Netflix. There's no dispute that Netflix was timely served.
Yep, no, I understand that.
Thank you, Your Honor.
All right.
Your Honor, Your Honor, this is Rita Walker on behalf of Netflix. We're, of course, happy to mediate. You've dangled some of your thinking in front of me on the pending motion to dismiss, and I don't know if you'll entertain even very brief remarks on that, but I obviously have a few things I'd like to say in response.
No, I mean, I've got your briefs, and as I said, my analysis is not complete, but I wanted to at least let you know where it was at this point, to the extent that may sort of guide folks in terms of where I'm going, and may aid you in the mediation. But I don't want to hear argument on it right now. If in the course of reviewing, working gave you a chance to argue it, but I'm not interested in further argument this morning. With all respect.
I understand, and we would appreciate the opportunity to be heard on the motion, if at all possible, before you make a decision.
All right. Thank you. I will keep that in mind. In the interim, we'll get a minute order in. There's a pending motion for somebody to withdraw, I think.
Yes, Your Honor. Lee Levine, after a very storied career, is retiring at the end of this year.
So I'll just grant that motion in the minutes. So that'll be just wrapped up on the docket. But otherwise, we'll enter a minute order. I'll wait to hear from the parties by January 4th. If you make your decision before then, and let me know, but you don't have to wait till January 4th, obviously. Just let me know. But I really do think this is a case that ought to settle, and it would be in everybody's best interest to settle it. So see what you can do, and if you can't, that's why I'm here. So I'll keep working on my decision, but I really encourage all of you to work hard to try to resolve this case through mediation. Thank you all for your time today. Happy holidays, and we'll perhaps speak in the new year.
Thank you, Judge.
Thank you so much.
Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Happy holidays as well.
Conference recording has stopped.